Okay, good evening, everyone. I'd like you to welcome all of you to tonight's webinar with Mike Dryden. And Mike can introduce himself and kick off the seminar. Mike, just tell me when you're ready to advance the slides, and I'll handle that for you from Harrisburg. So,
thank you, Jerry. And as always, thank you for the Institute and your efforts to get information out on topics that I think are important to everyone, but in particular to the firefighter community, public safety community. As Jerry said, my name is Mike Dryden. I am the head of the Workers' Compensation Department at a law firm in Philadelphia called Willig, Williams, and Davidson. We actually have offices across the state, even in Illinois and New Jersey. We represent firefighters, both paid and volunteer, all throughout Pennsylvania, and proudly represent them, try to help them with many different issues, including issues regarding work injuries. Our sort of goal with this training, and I think that the Institute's been very, very thoughtful in moving things forward to provide information to the volunteer community in particular that is similar to the information that we provide to the paid firefighters that we represent through the IAFF all throughout Pennsylvania. With that said, sort of the second slide, which I did lose. I just lost the slides, Sarah. They're just blank. But I know that slide basically says that volunteers are entitled to workers' compensation in the Commonwealth of Pennsylvania. You know, due to their volunteer service, the municipalities that you serve are responsible for carrying insurance. In my trips around the Commonwealth of Pennsylvania, I've had people come up to me and say, you know, I don't want to put a claim in against my volunteer company. I don't want to do anything that would hurt the company. You know, we're already sometimes strapped for money. The municipalities that you serve and, you know, serve as volunteers doing public safety work are by law responsible for covering you for work-related injuries in the service of the volunteer fire company. So it's not as if you're taking money off of the company. You are making a claim for workers' compensation benefits where the municipality either paid a premium to cover you or is statutorily required to cover you as a self-insured. So your right to that benefit is absolute under the law in Pennsylvania. Next slide, Jared. Please.
yep, you should be good, Mike. Next one's up.
I still have number 2. I'm looking for 3.
Hold on one second. How's that right there?
Nope, didn't change.
All right. Hold on one second. Let me do something here, Mike. Why don't you?
I have a sense of what that slide is anyway. So
yeah, it's I was going to have you control it from your location, but
see if I can do it. Let me see.
Yeah, let me do something here. I'm going to. You're going to have to bring it up on your computer. Okay. I'm going to give you control of it. You're the host. Okay.
Right. Bring the.
Yeah. Sorry, everybody. We'll get this kicked off shortly. Don't worry.
Bring it up from.
Yeah, from your computer. You put it on your computer, and then it says screen share right at the bottom of the Zoom. It says screen share.
All right.
You're going to click on that, and you should see that your PowerPoint there.
Sure. I don't know if I can bring it up. Share screen. No. I don't think I can do that with the computer that I'm working on, Jerry.
Okay. Well, let me try something back here, Mike. Hold on one second.
And I can sort of keep talking about what we're talking about. I apologize for the confusion.
Hold on one second.
I have to learn how to do this myself, which is one of my shortcomings is technical skills.
All right, hold on one second, Mike. All
right. Yep, that's the third one. So
right.
the workers' comp law, just as an overview, what does it provide for someone who's injured at work or injured as a volunteer firefighter or a member of a volunteer fire company doing something on behalf of the fire company. It provides wage loss, medical coverage for the work injury. Doesn't protect your job. It doesn't mean that your employer has to provide an extended period of disability, whatever disability entitlements you have at your specific employer outside of your volunteer service, they're going to apply. Sadly, the Workers' Comp Act has not evolved enough yet to cover employment and prevent an employer from letting you go after a work injury. And there's obviously, if you have a pension contribution that's being made for your paid job, your regular employment, it won't be made through the Workers' Comp Act if you're a volunteer. The last one, the importance of the CBA, we throw in for anyone who happens to be a volunteer firefighter who is a member of a union, that many times the collective bargaining agreements will have information in them about these other benefits, about your health insurance, about your protections for your job, things to just check. So basically, as an overview, what the Pennsylvania Workers' Comp Act provides is wage loss due to the work injury and medical care for the work injury and nothing else, just those two things. Next slide, if you can. Now we're rolling. There you go. And what injuries or illnesses are covered? And first, in 1972, they removed the requirement that you actually have an injury, that you have to come in and say that there was some accident or some fall down the steps or slip down a ladder. There is no requirement for an injury. Cumulative trauma is covered. Aggravation of pre-existing conditions are covered. There are examples of sort of problems that develop in all sorts of employment, but particularly for people who are working in the fire service, where if your back or your shoulder or something's worn out from the type of service that you're providing, you're done doing an overhaul and you walk out from doing an overhaul and your shoulders are really, really bothering you. If that turns into something that won't go away, you report it as a work injury and you can get medical care from it. You don't need one specific accident or injury to make the claim. It's particularly important with the aggravation of pre-existing conditions component to our law. Routinely, when someone's hurt, they'll be told that they have degenerative condition or they have arthritis. I'm 55 years old. I'm degenerating probably as we sit here. I mean, we all at a certain age start to develop things that are degenerative in nature, like arthritis. Now, while saying that you can get workers' comp for arthritis could be provocative, and there are certain circumstances with certain types of arthritis that you actually can, but more likely than not, what has happened is that someone who has an arthritic knee or shoulder or degeneration in their lumbar spine has aggravated that by the physical activities that they're doing as a member of the volunteer fire service. So if you, after reporting an injury, go to your doctor and they x-ray your knee and they go, wow, there's a lot of arthritis in that knee, that's what the problem is. It's the arthritis in your knee. But if that knee became symptomatic while you were lifting a generator for a response, or you were going up and down a ladder at a response, or you were working in the firehouse and you noticed that your knee just got boggy going up and down the steps, then that act of aggravating the arthritis becomes compensable under the Pennsylvania Workers' Compensation Act. So don't let a doctor or an insurance adjuster or even yourselves walk away from a claim that you could make that your service has aggravated an arthritic or degenerative condition and just accept that you're going to deal with it without making a claim, because they are very strong claims in Pennsylvania. They make sense to judges. If you're a 50-year-old volunteer firefighter who's got very, very sore knees and you explain that you're an insurance broker in your day job, and you're a bus driver or truck driver in your day job, but you volunteer and you're up and down ladders and you're training, and that's when your knees bother you, they will be solid claims for workers' compensation in Pennsylvania. And the direct trauma is easy. I mean, if you fall down a flight of steps or something falls on you, or you're in the middle of doing some work and get a sudden onset of pain, they're obviously claimable. Specific loss is a different section of the Workers' Comp Act. A specific loss started out as losing fingers, losing the use of a hand, arm, foot, and toes. It also includes having scars. Any scar above your collarbone is compensable as a disfigurement if it's permanent after 9 months. So if you're, if you get burned, like before hoods, years ago, before the hoods became more widely used, we would have firefighters who would get embers that would fall down inside their bunker gear in and around their neck, and even on the backs of their necks at times doing certain work. And they would lead to burns that would be permanent scarring. You can make a claim for the disfigurement of that, how that looks, and you'll be awarded from 0 to 275 weeks of what your workers' compensation rate is, which we can talk a little bit more about later and how that's calculated. But a disfigurement claim can be very significant. It can be a fair amount of money. Career firefighters that I've represented have had 2 or 3 of those over the years, and they can be tens of thousands of dollars, depending on how disfiguring the mark is. Diseases. Oh, let me back up one more thing on specific loss. Something that we're working on actually for the paid service, and I'm going to talk to Jerry once we get it up and running for the PFESI, is hearing loss. That many, as I'll not breaking news here, but many of the things that you guys deal with are very loud. And we successfully ran a hearing loss program for Local 22 years ago, and are back now again starting to evaluate that for the fire service to have people get their hearing tested. We can evaluate the tests. In order to claim a specific loss for hearing loss, you have to have above a 10.0% binaural hearing impairment, which is, there's a chart, there's a way that gets calculated. I can look at the audiogram and tell you if it's above a 10.0%. The thing about the way hearing loss cases are calculated in Pennsylvania that's always frustrated me is that they are done at a level of hearing that is below actual conversational speech. So someone could have a hearing loss that interferes with their ability to be in a conversation that requires a hearing aid, but not get one of these specific loss awards. We've come up with a way to make a claim for hearing aids on behalf of those people if it's due to work. Firefighters in the past that we've represented, we focused on in the paid service, we focused on equipment checks. I know equipment checks are something that happen in the volunteer service as well, and that people with very, very loud air horns, sirens on the fire ground themselves, and the different noises that you're going to come in contact with at a fire, small combustibles going off. There are a lot of different noise sources that we've used to make those claims. And if you get a physical, which I hope you all do, get a physical annually, and you think there's any reason to, or as you get a little older, I would encourage you to get an audiogram done to check your hearing, to be able to see if you're losing your hearing. And then we'll take a look at what your noise exposures are to see if there's a relationship between your fire service and your noise exposures. For the firefighters where we've won this claim, they get money if they have the specific loss number, but then they're entitled to the payment of reasonable, necessary, and related medical expenses, which basically means that the municipality has to pay for their hearing aids for the rest of their lives. So there are firefighters I represent who have the combination of tinnitus, which is like a ringing in your ears, and hearing loss. And there are hearing aids that help with both. They sort of dampen the ringing and elevate the ability to hear. They're costly, they're not cheap, but once we win these claims, the firefighter has a right to get them, then have them fixed or replaced as needed going forward. So hearing loss, I think, is a very important specific loss for firefighters. Most people, if they lose a finger or a hand or something, they're going to get a lawyer and they're going to figure out their rights. I think people with scars on their head, neck, or face, or their hearing is getting decreased, they sometimes will either ignore those things or they'll accept them and won't try to make claims when viable claims can be made. The next category is a very, very important category, particularly to me. It's diseases, illnesses, and virus. I'll focus primarily here on diseases. The Pennsylvania Workers' Compensation Act provides rebuttable presumptions for diseases of the heart, lungs, hepatitis C, and cancer for the fire service. The cancer presumption law that my firm was a part of and lobbying for even before it was passed, and working with the PFESI and other stakeholders, including the IAFF, to get passed back in 2011, has benefited a lot of families. I mean, it's sad. It's a sad situation when anybody gets diagnosed with cancer. It's particularly sad, I think, in the fire service because you have people who many times are younger than the median age for the cancer that's at issue, and many times have a more aggressive form of that cancer. So, this is the part of the presentation where I put my pitch in for best practices always including wearing the mask all the way through overhaul, having a diesel emissions capture system. If you do not have a diesel emissions capture system, then get a grant out there to try to get one. And diesel emissions are carcinogenic in and of themselves. They're a group 1 carcinogen for lung and bladder cancer, but they deliver a whole list of carcinogens to the human body that are both cancer promoting and cancer causing. Fire smoke has a laundry list of carcinogens in it. The smoke will devolve into soot, and if you get soot on your skin can absorb those carcinogens. So developing best practices is really, really crucial to any fire department, paid or volunteer. We recommend as best as possible doing gross decontamination at the fire scene or shortly thereafter, and taking a shower to get the soot off your skin as fast as you can. Not taking a shower that's overly hot because it opens your pores and can actually allow some of the carcinogens from the soot in. Kind of like a lukewarm shower seems to be best. To wear the SCBA mask all the way through overhaul. Studies on cancer in the fire service are somewhat varied as to what cancers are related to being a firefighter, but they are universal agreement on the hazard of overhaul. Overhaul's incomplete combustion. People are up there, the fire's knocked down, they think they're safe, they take that mask off and they start huffing and puffing and bringing some very, very nasty things into their bodies. And then the diesel capture systems, because diesel is another delivery system that, we sort of can reduce that if you have a capture system. Other thing, I was talking to a firefighter the other day and we were going over some times when the mask should be worn. And he had mentioned that in exterior firefighting, they wear it during car fires, but on dumpsters, they routinely do not wear it at dumpster fires. And dumpster fires are very, very dangerous, or maybe very dangerous if trash is burned at a certain temperature in a compacted setting. It can produce a certain type of dioxin that is the carcinogen that is one of the carcinogens found in Agent Orange. So as you're looking at that dumpster or trash fire in a confined space and you're not wearing your mask and you're sticking your head over there to see what was inside there or what was burning, instead of looking at that as just a small dumpster or trash fire, think of it as potentially Agent Orange and protect yourself. So diseases, to go back to the main topic today, is an overview of workers' comp. Obviously, if you have cancer and you're a firefighter, you should have it vetted for whether or not a claim can be made. If the claim can be made, you can get protection for yourself, protection for your family, and really win significant benefits. Even if you're a smoker, I've had people call and say, hey, I got cancer, but I'm a smoker, so I'm not going to try to make a claim. We've been successful at making claims. Not every cancer is related to cigarette smoking. And maybe more important is that not every cancer has the same level of relation to smoking. So smoking may be a cause of, it's obviously a cause of lung cancer. It's less obvious that it's a cause of certain leukemias or of non-Hodgkin's lymphoma, that it does play a role, but it plays less of a role. So when we're in court, we get to argue that your fire service exposure to these laundry lists of carcinogens that may be related to your specific cancer site, that they play a role that exceeds smoking. And we've been successful for many firefighters throughout Pennsylvania. Hepatitis C, we really don't see a lot of those claims anymore. I think the fire service is doing a much better job at avoiding bodily fluids. But if you get that diagnosis and you're a firefighter, you have a very strong presumption to make a claim. Heart and lung disease can be a little more delicate, and they are tougher claims. But I would encourage any firefighter who's diagnosed with any type of heart or lung disease to have the claim vetted. The people who do, our firm, at what we do for our clients, we do on a contingent fee basis. So if we're successful, we get 20% of what we win. we front the costs of the case. So the investigation of the case will never cost you anything. So if you think that you are potentially have been made sick by something that you've encountered in the fire service, we will take a look at it. We have experts who we can talk to. My main expert in the cancer cases is board certified as an occupational medicine physician, board certified as an internist, board certified as an environmental physician, has a master's of public health and also a toxicology degree. So we can talk to some very, very expert people who've been studying this for decades to see if there is a viable connection between whatever disease or illness you're facing and your fire service. And we put COVID in this because it's becoming more of an issue, or had been more of an issue. Hopefully it's waning. But if you can establish that you had contact with someone who was COVID positive, probably within 14 days of developing COVID yourself, and we can establish that in your personal life, you were relatively vigilant with the different things that people do to protect themselves, or you just, didn't really have a lot of interaction with anybody else. There are successful claims for COVID-19 being caused by a person's fire service. And most of those claims that we've been involved in have been for the paid fire service, but volunteers should know that, they have the ability to make this claim. They're tough claims. You got to have, pretty direct facts, direct exposures, and be able to really lay the claim out neatly for a judge, but they are still compensable for firefighters. The last, illness or injury that's covered is death. Section 307 of the Pennsylvania Workers' Comp Act provides what's called a fatal benefit rather, for the dependents of a worker who dies due to a work injury. Now, this obviously still applies to volunteers. If you are a volunteer firefighter and you pass away from cancer that we prove is due to your volunteer service, then your dependents, if you have a wife and 2 kids, they will get 2/3 of your pre-injury average weekly wage. If you have a wife and 1 child, it'll be 60%. If you have just a husband or a wife, a spouse, it will be 51% of your average weekly wage for the rest of your dependent spouse's life until or unless and until they remarry. So that benefit can really be significant for people. I think it's changed people's financial lives and set them up in a way that allowed them to parent children differently, allowed them to secure themselves in retirement differently. And, for me, I always look at that benefit, and we argue that benefit is claimable for a firefighter due to their service, because the injury is going to be related to their service. So if you've done something for the public, either as a paid or volunteer firefighter, and that's cost you your life, then we will do everything we can in our power to see that your dependents are taken care of to the full extent of the law. That's through 307 of the Workers' Comp Act. Pennsylvania also has Act 101, which is a line of duty death benefit that we've secured in addition to workers' comp benefits for volunteer firefighter dependents after the death of a volunteer firefighter that we proved to be due to exposures that led to cancer and during their fire service. So, it's a pretty significant list, I think, when you look at just the injuries, you look at the specific losses, diseases, illnesses, and death. There are benefits there for firefighters in all those categories. Next slide, please. What benefits are available through the Pennsylvania Workers' Compensation Law? And this, I sort of tread on this a little because I do jump around on the slides sometimes. Total disability, or Section 306A benefits, that's when you're totally out of work. So if something happens to you on the fire ground and you can't do your pre-injury job because of that injury, you hurt your back and you can't go back to work as a truck driver, they will owe you total disability benefits. That's going to be 2/3 of your average weekly wage up to a state maximum. Partial disability benefits, or what we call 306B benefits, that's when you return to work light duty, but you're not making the money that you made prior to the injury because of the injury. So it would be a situation where maybe you're a full-time carpenter, and when you're hurt, they put you in light duty and you're doing procurement, looking at plans for upcoming jobs, and they're only allowing you to work 20 hours a week and they're paying you a reduced rate. Partial disability benefits is the difference between your pre-injury average weekly wage and what you make in light duty. And you get 2/3 of that wage loss while you're in light duty due to a work injury for every week that you're there. It's a benefit that is frequently either ignored or missed by employers. To sort of put a monetary example to it, if when we calculate your pre-injury average weekly wage, say you work a lot of overtime and somebody is making $1,500 a week with their pre-injury average weekly wage, but when they work light duty, they only pay them $900 an hour. Then that $600 wage loss, you're going to be entitled to a second check through Section 306B of the Pennsylvania Workers' Compensation Law for $400 tax-free. So when you go back to work with restrictions, if it's for a work injury, you want to have your pay stubs and you want to compare, the year prior to your work injury. You want to establish your average weekly wage, compare that to what you're making in light duty. Specific losses, Section 306C, that's what I referenced before. There's sort of a draconian list of how much money you get or how many weeks you get for losing your hand, your arm, your foot, your fingers, those things. And if someone has that type of loss, for all intents and purposes, we invite them to call and we'll take them through the law for their specific loss so that we can determine what type of benefit is available to them monetarily and also to get the medical benefits that they would be entitled to. Medical benefits are found at Section 306 F.1 of the Act. Essentially, you're entitled to reasonable, necessary, and related medical care. So if you are someone who has been diagnosed with cancer and we successfully make the claim, if you have some HMO or you're captive to a local healthcare like Geisinger Healthcare, and you want to explore a different option, maybe at the University of Pennsylvania, if we win a workers' comp claim, the referral to the second opinion at Penn is reasonable and necessary and related medical care and would have to be paid for by the workers' compensation insurance carrier. We've had people since the cancer presumption law was passed who we've won for, who were treating for cancer in different areas of the state and were basically told to get their affairs in order, that there really was not a whole lot more that could be done for them. And they came to the University of Pennsylvania and found themselves into some kind of clinical trial and now are still alive and doing well. 2 people now being told they can't even find the cancer. So, one of the things I learned in this since 2011, I thought cancer care was sort of uniform, that all those doctors, they would share information in a way, and what you would get in Geisinger and Wilkes-Barre would be the same that you would get in the University of Pennsylvania in the city of Philadelphia or at the Cleveland Clinic or at UPMC in Pittsburgh. And I found that they're not, that there is a difference to the level of care and the level of innovation that's brought by some of those hospitals. If you win these claims, you have the ability to take that right to reasonable, necessary, and related medical care and go find the best care that you can find for your particular injury, disease, or illness. And the last benefit I've sort of talked about already, fatal benefits, is the money payable to the dependents of someone who dies due to a work-related injury or illness. And again, that's if a person dies and they have, a spouse and 2 children or more, it's 66 2/3% of their average weekly wage up to the state maximum. A spouse and 1 child is 60%. A spouse alone is 51%. And that benefit is for life unless there's they get remarried. Next slide, please. The first 21 days after a work injury, it's kind of an important process under our law. The Workers' Comp Act comes with obligations and rights. The employee has the first obligation under the law, and that is to provide notice. And notice has to be provided in sort of a specific way. It's not enough to walk up to your fire chief or to a county commissioner and say, my back hurts, or to tell them I have cancer, or to tell them that I have a heart problem. You have to say, I have cancer and I believe it's due to my fire service and I want workers' comp. I have a knee injury. I think it's due to my fire service and I want workers' comp. You have to specifically notify them of the problem. You don't have to know the exact diagnosis because many times at that early stage you will not, but you have to notify them of the problem you're having and that you believe it's due to work and that you want workers' compensation benefits. That's how notice is provided. If you look at any literature on the Workers' Comp Act in Pennsylvania, there's a lot of emphasis on notice. The employee is obligated to provide notice. You have to provide that, and you have up to 120 days to provide it, and before you're thrown out and your claim is not allowed to be brought. It's barred. But we like to have that done within the first 21 days, because if you do it in the first 21 days, then they have to pay you and pay your medical expenses right from the beginning of your disability, right from the beginning, from the injury forward. If you wait past 120 days and say provide notice on day 30, then you give the insurance company a 30-day holiday. If you wait to day 121 and they can prove that, they can completely block your right to bring a claim. So notice is important. You should notify the employer, even if it's just precautionary. Even if it's something that you're not, you get chest pain on a fire ground, but you're not sure if it's indigestion or you're not sure what it is. I would notify my chief that we were working the other day and I got chest pain. I think it was due to my work on the fire ground. Then you go get it worked up, and hopefully it was just, a bad burrito or something, and not something that is going to be an issue, not something really related to your heart. But if it later found out to be, it would be important to have provided notice. After the employee provides notice, the obligation flips to the employer. The employer has 21 days after you provide notice of a work injury to send you a notice of compensation payable, a temporary notice of compensation payable, or a notice of denial. They do not have to accept the case, but they have to let the worker know, or the volunteer firefighter know, of where they stand in the system. The notice of compensation payable is a form created by the Commonwealth, but it's filled out by the employer or municipality's insurance company. So it'll state the person's name and address. It'll state some brief thing about how the injury was purported to have occurred, what the injury is or what part of the body's involved, and how much money they're going to pay you. And the notice of compensation payable gets filed with the state, and that kicks a lot of rights on for an employee. So making sure that you get that after you report an injury is critical. It's like maybe the first thing we advise people all the time. When we open a file, we write to the Bureau of Workers' Compensation in Harrisburg to see what's on file, because what's on file is the truth of what happened after you reported the work injury. They can also issue a temporary notice of compensation payable, which basically gives the employer a 90-day window to back out of the acceptance. The notice of denial means they're saying right at the gate, this is not work related. The only good news with a notice of compensation denial is that you then get to go immediately to your own doctor. Because after you report a work injury, the employer or the volunteer fire company should have available a list of panel doctors. That's the next bullet point, that there's going to be a list of doctors for where they want you to go. Now, it should be a list. It shouldn't just be one place. We go to urgent care or Concentra or whatever, WorkNet. That they are supposed to supply a list that has to have at least 3 doctors on it, and then they can have 3 nurse practitioner. You could have some of those urgent care facilities can be listed there, but they're supposed to give the worker a choice. The regulations that accompany the Pennsylvania Workers' Compensation Act actually forbid an employer from controlling the worker's choice. In my world, we represent a lot of unionized employees against very, very large employers. And and routinely we find these large employers try to send workers to one place all the time. You're in one spot. And in my experience, that's not because that's where we're getting the best medical care. That's because that's a very employer-friendly medical provider. And we instruct the unions to, if that's happening, to enforce their right to that list and the choice. And the same applies to volunteer firefighters, the same way it applies to every other injured worker in the Commonwealth of Pennsylvania. So if you're hurt on the job and somebody says, go to urgent care, go to this one place, you want to say, no, I'm supposed to get a list. Give me the list. And if you don't get a list, you can actually go wherever you want. Now, also for volunteers, by the nature of what you do, if it's an emergent situation, you don't need to wait for the list. I mean, if you're hurt on the fire ground and you got blood coming out of your arm, you go to the ER, and they're going to be responsible for paying for the medical care that you receive from the pay that you receive from the emergency room. The bottom, again, I reiterate, just so I remind myself actually when I do this, of the importance of the notice of compensation payable and the notice of compensation denial. And even the notice of compensation payable in law school, we focus a lot on sort of reading critically reading documents. And, for me, I always kind of boil that down to reading a document and looking at it and trying to determine how this could screw me. I'm reading this thing and like, what's the most negative view to take of this? My grandmother is one of the nicest people, my mother's mother, on maternal grandmother, is off the boat Irish lady who was really, really sweet and nice. And she could get an eviction notice and in 5 minutes have that feel like a Christmas card. There was just a way that she had of trying to find the good in everything, and even in the things that she got in mail that clearly weren't. When you're dealing after a work injury with an insurance company, every piece of paper you get has to be read critically, which means not looking at it as if it were a Christmas card, but looking at it, if something's missing, it's missing for a reason. If something's inaccurate, it has to be addressed. The notice of compensation payable, when you get one, you want to read it to make sure if you hurt your back and your wrist, that if it doesn't mention your back, that's not like an oversight that is no big deal. We're going to have to deal with that. If they call something a sprain and you've already had an MRI that shows it's a tear, that's something that we're going to have to deal with. And those, either omissions or inaccuracies are things that you're going to want to bring to the attention of the insurance company first to see if they'll voluntarily correct it. If they won't, you can get a lawyer, hopefully us, and we'll go to court and we will fix it in front of a workers' comp judge. But they are important things that can come back to bite you later if you sleep on your rights. So the first thing is to know to get the notice of compensation payable. And then secondly, read it critically to make sure it's accurate with what you believe your injury is, what the doctor's telling you your injury it is, and then get good care. If they issue the notice of compensation payable, you have to treat with one of their doctors for up to 90 days or for 90 days from your first visit with that doctor. So you want to see a doctor as soon as you can, make it a panel doctor. That starts this 90-day clock. And then my advice is always to get away from those doctors. Go see your family doctor and find a specialist that you pick to see. So we'll go to the next slide now. Other benefits available, and now these aren't available because you're a volunteer firefighter, but they can be available to other bargaining unit members. The Heart and Lung Act, Act 534, Heart and Lung Act is available for uniformed public safety employees, not available for volunteers. So if somebody's talking to you about your rights under the Heart and Lung Act, you do not have rights under the Heart and Lung Act. You have rights under the Pennsylvania Workers' Comp Act. Act 534 and Act 632 are actually the same law, but for different bargaining units. And they deal with the Department of Corrections and they deal with Department of Human Services. Also, volunteers, firefighters, not eligible for that type of benefit either. And normally we don't see that come up. We will have confusion about the heart and lung. Social Security disability is available to everybody. If you have a disability that takes you out of all work, you can make a claim for Social Security disability right along with a workers' comp claim. And, for the most part, we will have that discussion with people as we read their medical records and we see how their impairment and how their injury proceeds. But you do have a right, like everybody else, to collect Social Security disability for injuries that occur in the service of a volunteer fire company. Next slide, please. The Pennsylvania Workers' Comp Act specifically protects the employer from claims for pain and suffering or civil lawsuits. There's something in the law called the exclusivity provision that's referenced in the first bullet point. But that doesn't mean that there aren't third parties that could be available to sue. If we've had cases for paid firefighters where, a restaurant goes up in fire, goes up and there's a sort of like a toaster oven type thing that was supposed to be recalled, that wasn't recalled, and that led to the fire. And because of the fire, someone was horribly injured. A firefighter was horribly injured. They could arguably have a case, and in that case did have a claim against the manufacturer of that toaster oven, and the property owner where the injury happened. They wouldn't be able to sue their own fire department or municipality, but they can sue third parties. We see this in cases involving properties. We see this in cases involving, ice removal. We see this in products liability cases. You're probably inundated with letters about PFAS and that those chemicals and what those chemicals could mean to you. And the literature on that is evolving. So there probably will be more that you're going to hear in the future about those types of claims. Something I think that is important for the fire service to sort of keep an eye on is spoliation is a concept in the law, that if you're going to try to say that a product malfunctioned and led to injury, you have to sort of have it there to be investigated. So if you're doing work at a fire and something malfunctions, if you throw that in the dumpster or it disappears, there will be no ability for potentially a very horribly injured firefighter to make a claim against the manufacturer of that product, because it wasn't there to be proven that was the negligent cause of the fire, and would block any kind of claim. So if you go into a setting and there's fire investigation, you're going to get a good report. If there turns out to be some toaster oven or something that malfunctioned, you're going to want to make sure that's secured so that anybody who may have a claim has the ability to bring the claim. Because the Pennsylvania Workers' Compensation Act does not provide any benefits. All the way back to the beginning of our talk tonight, it only provides wage loss for the work injury and medical coverage for the work injury. The fact that you have pain every day that you get out of bed, the fact that you can't play with your kids or grandkids, the fact that you can't straighten your left leg because of the pain in it, the compact really doesn't give you anything for those things. Third-party lawsuits, personal injury lawsuits, medical malpractice claims, they are where those types of damages are compensated. Medical malpractice is listed there just as another thing that we evaluate, and I think any injured worker should evaluate the medical care that they're receiving. If that medical care is negligent, just because it's for a work injury, doesn't stop you from bringing a medical malpractice action. Just because you're a volunteer firefighter, you're not prevented from bringing a medical malpractice action against someone who's treating you for a work injury. Just because they're listed panel doctors doesn't insulate them from a medical malpractice action. If they've provided negligent medical care and it's damaged you, you have a right to make a medical malpractice claim, sort of period, end of sentence. Subrogation is a concept whereby the workers' comp carrier is repaid from money that you receive from the negligent party. Something we explain a lot more in cases, but if you have now going a third party case, an auto accident case, you're on your way to a response on the fire apparatus, and the fire apparatus gets T-boned by a UPS truck. You're going to have a workers' comp right against your municipality, and you're going to have a third party auto accident claim against UPS for the negligence of its driver. If you recover money from UPS, the workers' comp carrier will have their hand out to get money back for what was paid in the workers' comp case. So it's not as if you get to completely stack both of those. Probably about 2/3 of what was paid in workers' comp is accessible for the workers' comp carrier against the third party. So just beware of the fact that you have potentially more than one claim, same as anybody else. And that though, if you do make a claim successfully for damages, that the workers' comp people will have a right to get some of their money back. Next slide, please. Retirement after a work injury, pension offset against workers' comp, heart and lung, Act 534, 632. They really don't apply to you guys. It's in there more to say that they don't apply. Medical coverage for the work injury is something that should continue even if you retire after a work injury. But if you receive a pension and you are a municipal employee, so some places, if you work for the same municipality that you volunteer for, There will be a good fight about whether or not they get to reduce how much workers' comp they have to pay because you're getting a pension that they funded. We fight that in the volunteer fire community because you're a volunteer. When you're injured, you're not a traditional employee. But the Pennsylvania Workers' Compensation Act at Section 203 of the Act gives an employer the right to reduce its obligation to pay workers' comp by the portion of an employee's pension that it funds. So when you are, if you are an employee of the municipality that you serve and you're on workers' comp, before you retire, you want to have a really detailed conversation with an attorney who understands how those laws how pension rights and workers' comp rights interact with one another. If you are, if you're going to retire and get a pension from a completely unaffiliated entity, if you're an employee at the Commonwealth of Pennsylvania and you're hurt as a volunteer firefighter and receiving workers' comp as a volunteer firefighter from your municipality, the municipality does not have a right to take an offset for your pension. So if you're involved in any kind of settlement negotiations or you go to get that pension and someone tells you that they're going to reduce your comp, they would be incorrect. But if you have any questions, please call. When people get to that point, when they get to the point where they're retiring and taking their pension and they're getting workers' comp, they're trying to figure out how they're going to have money to live on at an advanced age and when their working life has ended, has stopped in many cases. And, it's serious business doing that. And you have to really put your pen to paper and do the math to see what's available to you, how much of it you're going to retain, and whether it's going to be enough. And we have those conversations with clients, all the time. So feel free to call if you find yourself in that situation. Next slide, please. Best practices. First off, as far as notice goes, we had talked about it before, to provide it within 21 days. I like providing it or having it provided in writing or email. There can be no nonsense about what was said if you provide written notice. But if you're going to provide written notice, you want to make sure that you're very clearly saying, I have injured my low back. I believe it's due to my fire service and I want coverage from workers' comp. Or I have cancer and I believe it's due to my fire service exposures and I want workers' comp coverage. Or if you're in leadership in a volunteer fire community, you can develop some type of form for your member to fill out that meets those notice criteria, with just having those things filled in before you send it over to the municipality to have the claim processed. And demand a copy of the notice of compensation payable or denial. I said earlier, and I correctly said earlier, that you're supposed to get a copy, but routinely insurance companies do not provide the injured worker copies of those forms. They'll file them with the state, but kind of leave you in the dark as to where you stand. After 21 days from you reporting the injury, you're supposed to receive one of those things. Now, the mail's been a little sketchy the last couple of years, so maybe something's a couple days late. But after the injury, I would get the phone number and email for the adjuster responsible for your claim. I should probably add that to this best practices, so that you can contact them and say, I provided notice January 1, 2023. We're now at January 23, 2003, and I have not received a notice of compensation of denial or notice of compensation payable. Please advise when I should expect to receive that. I know I'm entitled to it within 21 days. And, if I don't hear from you, I'm going to get counsel. And maybe you'll shake them up enough to send you the document that the law says you're entitled to. But you want to have that in your hand. It's kind of your ticket to ride in the comp system. And it describes your injury, like I said, and how much you're going to be paid. Very, very important things. And demand quality medical care. And too often, people are soft with these doctors. They don't expect much from them because they're company doctors, and they let them get away with a lot of nonsense. When you're in there after a work injury and you're with the doctor, think of yourself as if you're standing next to one of your kids. Would I allow my kid to be treated this way? And demand the doctor provide you the best care that he can or she can, or find another doctor, because you have a right to second opinion. Get copies of your medical records. Always part of what we tell our clients to do. They won't have, if you go to the doctor today, they don't real time write you a note. But if you go to the doctor today, you can ask them for the last visit if you were there 2 weeks ago. You want to kind of keep your own file of what's going on. Know your CBA is always in here, because, I'm a union lawyer, along with representing non-union people. We represent a lot of union folks. And I know from that a lot of union folks are members of the volunteer fire service. Just know your collective bargaining agreement. If you're hurt as a volunteer firefighter, how long you're going to have health insurance, how long you're going to have a job, how long you have to get back to work before you lose your seniority. All of that stuff is going to be spelled out in the collective bargaining agreement. If you're not in a union, then the best that you're going to have is the FMLA, the Family Medical Leave Act. But you're an employee at will, and they can pretty much tell you what they want to tell you if you're not in a union. So, know your CBA if you have one, and if you don't have one, know that you're probably more protected if you did. And the last is to consult an experienced attorney. As I said earlier, no one's going to send you a bill if you call me. I'm not going to send you a letter, say we talked for a half hour and here's my rate for a half hour. You're free. There's my contact information to contact us at our toll-free number. That number is actually on a laminated posting that is on a lot of firehouse and employee bulletin boards across Pennsylvania. My direct dial, that's my direct dial, my office number. The email is there as well correctly. My rule for my department and the attorneys that work for me in it are that we get back within a maximum of 24 hours, normally less. But if you don't hear from us in a day, you feel free to call me back and say, we didn't live up to what I said we would do, but we're going to get back to you because I know these are very, very important issues that many times are time sensitive. When you're hurt on the job, you have to be cognizant of the fact that after you report your injury, it's going into your claim is going into a system with insurance adjusters, vocational consultants, panel doctors, all of whom are paid to save the insurance company money and not to protect you. And that you have to have your hands up and protect you, not just for yourself, but for your family, because you're dealing with your income, the thing that helps put food on a table and a roof over your head. And the people that you're dealing with, the insurance companies, really don't care about your ability to do that. If they can save 5 cents because you made a mistake, they're going to save 5 cents because you made a mistake. And as a member of the volunteer fire service in Pennsylvania, as a supporter of the PFESI, you can contact me and I will tell you what I think the situation is and what I think you need to do. And we'll try to help you steer clear of that. With that, I am completed my part of the presentation. I certainly will answer any questions that anybody has about anything I've said or any of the issues that are pertinent to you as a member of the volunteer fire service or a worker in Pennsylvania.
Well, thank you very much, Mike. Does anybody have any questions? You just kind of identify yourself pretty quick and just go ahead and ask any questions you might have.
Jerry and Mike, this is Ed Mann. I don't have a question, but I have two comments. If, as a former fire chief if any of your people go to the emergency room as a result of an injury or an illness from the fire department, when they process through the emergency room, make sure they tell the emergency room they are there with, in my case, the Derry Township workers' comp. Because if you give them your own insurance information, guess what's going to happen? Your own insurance is going to get billed for that injury rather than workers' comp. So I know in my municipality, if we had an injury, I simply sent an email to the township secretary, told her that Johnny New Boots went to the emergency room because he got hurt at a fire. So she had that first notice of claim. But make sure the emergency room or the doctor knows that it's the municipality's workers' comp and not your own insurance. And the other comment is, if you have a fireman's relief policy, and I don't care who the carrier is, if you file a workers' comp claim, file a claim with your fireman's relief insurance policy as well.
Good points, because the co-pays for an emergency room visit and most policies are pretty stiff. And I can't see you, Ed, but I also credit Ed with some really good guidance about gross decontamination at the fire scene. Like, he's one of the first people, Don Conkle and I spoke about cancer at his his volunteer fire company, and had a real good back and forth, and they had really, really good ideas about that, which always is something that I am encouraged about in the volunteer fire service. I frankly think the volunteers are ahead of the career departments on cancer, on protecting yourselves from the carcinogens, and some of it is because I think you share ideas with one another, and you're able to implement things in a way a little quicker maybe than the municipalities are. But Ed and Don, there's Jerry, there are some really good leaders in this community. Tim Salabay is another one that has helped and guided me at times to help me understand more about what we were facing and trying to help people protect themselves better. So I just want to thank really Ed and Jerry always for having me on. I always that meeting and the way that it was done, the care that it was done, the thoughtfulness down to the little details about how best to do that, I was always impressed by. So and not to put more on Ed's plate, but if anyone has questions about how to do that gross decontamination, I have just volunteered Ed to answer those, because he was very, very thoughtful, and that was a couple years ago. So I'm sure he's got a couple new tricks up his sleeve. Any other questions?
Other questions? Anybody else have any other questions?
Jerry, quick question, and I'm not sure if it's for you or Ed or not, but I was on a meeting a couple months ago, and it made a comment. This is kind of like after the fact, somebody gets hurt, claims, so on and so forth. But the question I had is the reporting side. I hear bits and pieces like the reporting side goes to the township, but in reality, it should also be reported to the state. Is that correct?
For reporting of an injury?
Yes.
Well, yeah, it goes to the township or the municipality first, and then the municipality is going to file that notice of compensation payable or notice of denial with the state, with the Department of Labor and Industry. Bureau of Workers' Comp is part of the Department of Labor and Industry. So you're if you think of it in terms of like a chain of command or a chain of action, you're reporting to your municipality, whoever the human resources person is who handles that, and you're making a claim for workers' comp that they're going to give to their insurance company, and the insurance company is statutorily required to go to the state.
What about just an injury in general? Because doesn't the fire commissioner's office kind of keep tabs or reporting on injuries?
So I can tell you that some county 911 centers are very good about reporting stuff to the EOC, to the Emergency Operations Center at Pima. Other counties not so good. My understanding is the regulations from the state to EOCs tied to grant money have changed recently, and they're supposed to be reporting injuries and specifically line of duty deaths to the EOC. So the fire commissioner gets notified, in particular on line of duty deaths. And I've been out of the office 8 years, but I used to get reports of injuries from the EOC on a pretty regular basis, but it all depends on the county you're in and whether or not the 911 center is reporting it to the state EOC.
Hey, this is Jerry. Ed is exactly correct. I have just heard there has been an increased interest in collecting data from the Office of the State Fire Commissioner on injuries. Okay, I don't. There's nothing official out there, and I don't think there's anybody on from the office. Hold on. There. I did see a name pop up here. Joe, I don't know if you're permitted to say anything about that since you're on here from the office, but I know there's been I know it's important to talk about to track injuries in Pennsylvania, and so.
Yeah, they're doing the tracking of the injuries and the line of duty deaths. They do still come over to web EOC. They are just being recorded to try and see if there's a difference with the data and if there's a certain trend that's being carried out, and they're trying to see if there's anything else to be implemented. They're just following the EOC guidelines as of right now, and then they do a follow-up later on after the injury with the chief.
Joe, Joe, you want to introduce yourself real quick?
So I'm Joe Bynum. I work at the Commissioner's Office. I do the First State Program Manager, so all the incident reporting. That's what my main title is, what I do for the office, and just participating and keeping track of all the civilian fire deaths for the state as well.
So thank you. I did have a question come in via Mike. It's if a firefighter fails to properly use personal protective gear that is provided, can benefits be lost? That's one question.
No, the Pennsylvania Workers' Comp Act is a no-fault disability system. So if someone, doesn't wear the mask the right way, or doesn't do something that they're supposed to, do, or doesn't wear it long enough into a setting, or they don't wear the correct boots, they will not exclude themselves for workers' comp. The only thing that sometimes we will see come up, there's a concept in our law of somebody violating a direct work order. So if you violate a direct work order, there's a possibility that the claim can be denied. It becomes what we call an affirmative defense. The insurance carrier can say, hey, this guy was injured because, he had the wrong shoes on, and I directly told him that everybody's got to wear fire boots, or they got to wear this, or they got to wear some specific equipment. And in this setting, the person didn't do it. The problem is that in most situations where that occurs, the situation's fluid. There's a boot missing, and they're going inside because there's a small complement of people, and he's either going to go in with the one boot he's got and his personal shoe, or he's not going in. And they'll go in, and that won't normally, in my experience, block them from getting benefits. It is a very, very hard affirmative defense for the insurance company to make. In workers' comp, because it's a no-fault disability, and law, the concepts of like contributory negligence, where like you're half at fault for what happened, they really don't apply in the workers' compensation system. Even in the cancer setting, we had municipalities come and they said, hey, look, well, we have an SOP that says you have to wear the SCBA mask on your face all the way through overhaul. And they originally started to, in a couple of cases, started to think about trying to push the idea that the firefighter would not be able to make a claim for cancer because he had testified that he didn't wear it during overhaul, and they had this SOP. And then we subpoenaed and asked them, demanded really, the list of every firefighter who was ever disciplined for not wearing the mask all the way through overhaul. And at the municipal fire companies where we've made that request, the answer came back always as 0, that they had never disciplined anybody. So the direct work order has to be a legitimate direct order. I mean, you could write a standard operating procedure that simply says, don't get hurt. And then you got hurt, so you violated the SOP, and try to, like the SOP has to A, be fair, and has to be in something that they're actually trying to enforce. So if you have a standard operating procedure that says that you have to always have the mask on during overhaul, but never ever have disciplined anybody in the 15 years that it's been an SOP, it's really hard to say that it actually is a standing work order. So I wouldn't be worried too much about that.
Mike, does the same apply if you violate the law? For example, you're driving an emergency vehicle, you're involved in an accident, and you get cited by the police department for driving too fast for conditions, and you end up with a citation from a law enforcement agency. Does the same thing apply?
That's a real tough case. That's a really, really tough case. I mean, I think, the violation of the law in the speeding sense, I would take a run at that and try to say that speeding to get to this fire scene becomes more of a negligence component than a positive work order setting or breaking the law. Most times, if you're breaking the law, like we have people who will sometimes be found later to have pot in their blood, like a little THC will come up or something in there. They have to be able to associate what you did to break the law with how you were hurt. That's why your example is really kind of a good law school level question, because it is, the speeding arguably is why the accident happened, or they'd have to establish that that's why the accident happened, and then be able to, from that, prove that that should disqualify him for comp? That would be a really good question. Sitting here, I don't know the specific answer. It would be decided by a judge based on the totality of the circumstances. And, you know, I couldn't say for sure that the person would get benefits or that they would be blocked.
All right, the only reason I asked the question is it was non-emergency. The individual was returning from a parade, wrecked the vehicle, killed one individual. He was severely injured. And as I recall, workers' comp was denied because a police officer cited him for driving too fast for condition. They also questioned whether or not the individual had a couple of beers after the parade was over before he get behind the steering wheel, et cetera, et cetera.
Yeah, see, I would attack that if I were defending that case. I would attack that as questioning whether or not coming back from the parade in that manner and having a couple of beers were things that were diversions from his service to the volunteer fire company and take him out of the coverage of the law, more than try to say that breaking the law is why we're not giving him the benefit that he just wasn't in the course of his volunteer service when he was doing what he was doing. But it would be, again, it would be up to the judge. You know, it really depends. I mean, in the workers' comp system, the cases get decided by one judge. So if we bring a case for Ed Mann versus whoever, then there's one judge who's going to decide it. And if that firefighter that you're describing for me, Ed, is a 19-year-old kid who now is going to be profoundly disabled for the rest of his life, you know, will a judge say that because of, you know, a possibility of 2 beers and a little bit of too much speed, I'm going to give him nothing? You know, so there's a human component to these cases, but the totality of the circumstances would be played out in that setting. I think he'd find a lawyer to bring that case. We'd bring that case for him to try it, I guess, if he came to us, and we'd have to check the facts. But the judge would ultimately determine. Sorry, I don't have a more specific answer to that one. They're 2 good questions.
Go ahead.
I wasn't sure if Mike or Ed said something about on a for insurance claim, I guess, notify the relief. If your township is covering the workers' comp, what was the thought for the relief, or did I miss that?
I'll give that one to you, Ed. Why would you notify to notify
the entire question?
It was, why would you notify the Firefightermen's Relief Association if you have a work injury?
Well, because depending on the policy you have for your fireman's relief, there are benefits. So for example, if workers' comp denies the claim, if you have a decent fireman's relief policy, there's money in that policy to protect your wages. Even if workers' comp decides to pay, if you're short on wages, depending on your policy, there's money in that policy to make you whole. If you have to go, say you're admitted to the hospital, a lot of those policies have a hospital confinement. They pay you every day you're confined to the hospital. If you have outpatient care, every time you go to the doctor, depending on the policy you have, it pays you money to go to the doctor in an outpatient setting. If you can't go back to work at your same job, depending on your policy, there's money there to be able to pay to retrain you. If your house has to be modified because you're going to be confined to a wheelchair, or you need a ramp, again, depending on the fireman's relief policy you have, there's money there to take care of that, in addition to the death benefit and all the other benefits that are part of those policies. So my suggestion would be, find out who your carrier is for your fireman's relief policy, have them sit down with you and explain all those benefits. And my rule of thumb is, if you're filing a workers' comp claim, you should be filing a first notice of claim with your fireman's relief insurance carrier. At least the claim's open. So if anything becomes of it down the road, you've got the paperwork in the system that you were injured or filed a claim on any given day.
Okay, thank you.
I got a question that came in via the chat. Department members that are 60 and 70 years old and are retired and they're injured as a volunteer firefighter, are they covered under the workers' comp in Pennsylvania?
Yes. If they're disabled from firefighting, they can receive a claim. One of the things that I didn't say in the presentation is a firefighter is entitled to a minimum. There's a minimum average weekly wage that gets installed through Section 601 of the Workers' Comp Act. So the statewide average weekly wage is the worst that a volunteer firefighter can do as far as the percentage, as far as the average weekly wage that they are going to receive. And so if you're retired already and you're not working, then you would get the statewide average weekly wage put in as your, as if they were your earnings. And then you'd be eligible to receive workers' comp while you were disabled from firefighting.
Thank you, Mike. I have another one. Can a municipality make a volunteer firefighter quit based on a settlement through workers' compensation?
No. I mean, for me, we've had that proposed to us more than once. And it, again, the same way that the workers' comp law only provides wage loss due to a work injury and medical for the work injury, that the workers' comp judge has no jurisdiction over that. Now, when it's a settlement negotiation, there's a lot of things that people will say, well, we're only going to settle with you if you sign this agreement. And an insurance company could say that, a municipality could say that the only way we're settling with you is for that. But to actually go somewhere and enforce that, if the person does not want to do it, to make them do that, there's no way to do that in the workers' comp system. So while there's no way to do it in the workers' comp system, somebody, if they were offered, here's $1 million, if you'll settle your comp case and agree to sign this piece of paper that you're never going to volunteer to us again, the person could make the choice to do that, but they really can't force you to do that, if that answers the question.
I think that you answered that correctly. And there's another one here that was put in regards to being not an active firefighter, but can be an administrative. Let me read it to you. I understand that legislation was enacted regarding workers' comp benefits for members of fire companies that are not active firefighters, but rather serve in support or administrative capacities. Could you elaborate on this new process?
Well, I think some of it, and again, I am not as familiar with that law in my world in workers' comp. If you are injured in the performance of some duty that benefits the volunteer fire company, if you are carrying rolls at a fundraiser, and because you're carrying the rolls, you don't see a hole in the lawn and you tread in the lawn and tear a ligament in your knee, that's a workers' comp case, regardless of whether you're on the active rolls as a firefighter or not. I think that there is a movement to try to more precisely define who the firefighters are for the cancer presumption and for some of the disease presumption portions of our statute. But if you're still a member for the cancer presumption, you have to go fight fires. So I am not, I don't see that as something that really changes my world at all. And I'm not actually familiar with the legislation.
So I am a little bit familiar with it, and it is called, they're asking that they change the classifications of membership in the volunteer fire company. The term social member was a red flag in some organizations because of the historical social clubs where there's 200 members that pay their $5 for a bar. The word that they like you to use is contributing member, or something similar to that, where they are contributing to the fundraising and or support of the fire company, that those contributing members are identified on a roster somewhere, and that that roster is approved ahead of time by the township when they normally authorize your activities. It came out of a case in South Central County where there was a person that tripped over a circus tent stake, the post that goes in, and messed up an ankle. The person was not classified under the roster of the fire department, and there was a whole bunch of back and forth that required some changes in legislation. Now, the person eventually got covered, but there was some questions with that. So That's what it's called. The member needs to be contributing to the organization to be covered. And it should not be just a member who pays their $5 and goes to the club. Any other questions? All right. With that in mind, I'd like to thank Mike Dryden for presenting for us tonight. Appreciate everyone's feedback with this important topic. We've got one more session in our, this is our third session. We have one more next week on firefighter and youth camps and information like that. We certainly appreciate your support of the PFESI and everything that we do. And thank you very much. I've recorded this and I'll be able to send out Mike's PowerPoint with his contact information to all of you. With that, that's all we're doing tonight. So thank you very much for attending. Have a nice evening.
Take care. Bye-bye, everyone.